I'm very sorry that I can't be with you in Taipei today, but I am very happy to have an opportunity to share some thoughts with you about the role of lawyers in transitional societies. In democratic societies, of course, lawyers, I'd like to say, are not dentists. Now, why do I say that? I admire dentists. They have to do highly skilled technical work and literally in your face. If they make a mistake, we immediately know that, and we respect them for their high professional ability. But lawyers, although they're supposed to be technically proficient, and usually are more than dentists. We expect lawyers in democratic societies to play a broad, useful role as citizens. Of course, most lawyers are busy making a living. They do commercial work. They settle family disputes. They do a lot of ordinary things. But in democratic societies, at least a minority of lawyers do more than that. They're public people, and they help in various critical ways. Lawyers help, if they're public lawyers, to articulate the highest values of a society. But they do more than that. They help to write the rules of society, to establish and implement the institutions required to apply the rules. They emphasize the importance of procedures, fair procedures. And lawyers take part, public lawyers, not only in shaping general rules and principles, but also in concrete cases, in controversies, in applying the rules in as fair a way as possible in order to make democratic societies function better. They operate, as I like to say, retail as well as wholesale. They may take part in negotiations, mediation, arbitration, adjudication, administrative lawsuits, and in criminal prosecutions. And lawyers operate in different ways. Some public lawyers serve the government. They're serving the community by working in the government. They work, of course, as prosecutors and judges, and they work as arbitrators, in addition to helping to draft the rules. They're often administrators in government when they work in ministries of justice, for example. But of course, other public lawyers serve the society by often challenging the government. They find it necessary to not always accept the government's case of things, but to provide independent, learned counsel to various groups in society. This creates controversy. And those public lawyers who engage in challenging the government, ironically, are referred to, like commercial lawyers also, as it being engaged in private practice. That's to distinguish them from lawyers who work in government roles. But of course, public lawyers, and by that I mean not only human rights lawyers who are so designated and recognized, but often ordinary criminal defense lawyers and public interest lawyers who bring suits on behalf of NGOs and other organizations and people. These people are engaged in a very special form of private practice that really is very much a public practice. Now, we're talking not about lawyers in fully democratic societies today, but we're talking about lawyers in societies that want to make a transition from authoritarian dictatorship to democratic politics, to the rule of law, to the legal protection of human rights. And we have to ask, what can we expect from lawyers in those circumstances? We know that history shows in many countries that in transitional societies, lawyers play a very important role. Of course, the lawyers who serve economic development, the lawyers who serve dispute resolution play important roles. But today, I'm talking about political legal questions, because those are the key questions when societies try to make this difficult transition from authoritarianism to democracy. This is often dangerous work. If you challenge the government, if you challenge the dominant political and economic power in your society, you are sticking your chin out often. And sometimes lawyers pay a heavy price. Certainly, it's not a fashionable way to make a handsome, profitable living. It requires a degree of idealism that is truly impressive. Some of these ideals that seem to fuel the energy and the courage of public lawyers in transitional societies are those ideals of Western democracy, rule of law, human rights that have now become universal principles practiced in many Asian countries and other non-Western countries. Some public lawyers are fueled by political motivations. They're interested in politics in the conventional sense, or they're interested in promoting a different kind of economic system, or they have different social values or religious values. But whatever the motivation, the independent, courageous public lawyer plays an important role in societies that want to make the transition from dictatorship to democracy. Maybe the classic precedent is 18th century America, whereas Americans increasingly wanted to be separate from the motherland in England, lawyers played a very prominent role and a courageous role, and of course, subsequently throughout American history, a small minority of influential, courageous people have played a very, very important role. But East Asians don't have to look so far afield for models. In the contemporary East Asian world, we're in the right place when we have this discussion in Taiwan. I remember from the 60s and 70s and the early 80s, the handful of courageous Taiwan lawyers who were public lawyers and who inevitably challenged the cruel dictatorship of the Chiang Kai-shek regime and his heirs. And of course, I did work in the 70s in South Korea with some gallant public lawyers. The Philippines, when I visited there in 1980, I was struck talking to some of these public lawyers doing criminal justice, public interest work. I was struck by their courage, by their determination to continue to challenge the Marcos regime. So there are many examples, fortunately, around East Asia for us to look to. So this is the background against which I come to the crux of my talk today, which is the plight of public lawyers in contemporary mainland China. Some people tell me that public lawyering is growing in China, that despite repression of the Xi Jinping government, that there are increasing numbers of young, idealistic public lawyers. I have no way of verifying that, of course, because the oppressive government on the mainland is so non-transparent. It may well be the numbers are increasing despite the oppression and the sad fate suffered by many. It may be that the repression is triggering an increase in numbers. I'd like to think so. But whatever the situation, we know that the immediate future is depressing for those who want to see public lawyers flourish and improve Chinese society. Xi Jinping has almost 7 more years to go if he succeeds in getting a second term, and there's even talk already of perhaps he might want to do what President Park did in South Korea, Park Chung-hee, and what President Marcos did in the Philippines, and what the Jiang regime did in Taiwan, which is simply extend their rule beyond prescribed terms. I don't know. But what I do know is that the Xi Jinping regime today does not give us a very optimistic basis for the prospects of public lawyers on the mainland. You see, my view is Xi Jinping is a Leninist, a follower of Lenin. You know, Lenin, before the Bolshevik Revolution, was a lawyer. He had a short and undistinguished career trying to be a criminal defense lawyer before he decided that revolution was easier if you want to make real progress. But once the early years of what was called war communism of the Bolshevik regime ended, by the early 20s, Lenin saw that there was a need for what became the new economic policy, a policy of trying to attract the capitalists of Britain and France and elsewhere to invest in the newly socialist Russia. And Lenin saw that to do that and to make the economy of socialist Russia succeed, lawyers would be necessary. And what he did was gradually foster technical lawyers who could help with contracts, foreign investment, resolution of business disputes, etc. But Lenin never had the idea that the legal profession would grow to embrace public lawyers, lawyers who might challenge the government. This wasn't his idea at all. He didn't want to see lawyers become an instrument for protecting human rights, for promoting democratic values. He only believed in a limited version of the rule of law. Now, when Chairman Mao successfully led the revolution that established the people's government in 1949 on the mainland. He did engage for the first few years in a flirtation with the Soviet Leninist legal model that Stalin had perfected after Lenin's death. But by 1957, during the famous 100 Flowers Bloom movement, when there was too much criticism of the Communist Party and the lack of democracy, freedom, rule of law, etc., Mao decided that the Soviet lawyers' model didn't really suit China. And in the anti-rightist movement, the Fanyo Pa Yundong, that began in June of 1957, he abolished the legal profession. And the Great Leap Forward and ultimately the Cultural Revolution put an end to the legal institutions established under Soviet influence in the mid-1950s. There were some optimistic scholars, both inside and outside China, who naively believed that maybe this was blazing a new path for China. Maybe socialist China, different from the socialist communists of Eastern Europe and the Soviet Union, that maybe in China they didn't need lawyers. You could have development and a desirable society with law, but that law wouldn't require lawyers, even commercial lawyers, not to mention human rights lawyers. One of my best former students indeed published a book with the title, Law Without Lawyers. But this was before Deng Xiaoping returned to power after the Cultural Revolution. Deng, while he was suffering restriction and punishment during the years he was out of power in the Cultural Revolution, didn't have a chance to read any of these theories about law without lawyers, because when he came back to power, what we saw, he returned to the Soviet model that he had actually presided over in the mid-50s in China. He was Secretary General of the Communist Party at the time of the anti-rightist movement. And when things became much more radical, I'm sure Deng did not approve of this new radical phase. And when he came back in December 1978, and you had the famous third plenary session of the 11th Party Central Committee that established the new line emphasizing economic development and de-emphasizing class struggle, Deng brought back, he revived the Soviet model for a legal system in China. And that meant China began once again to develop what they called Falugu Wentru, legal advisory bureaus. They were modeled on the Soviet law firms, which were called colleges of advocates. And it brought back legal education that was still showing the Soviet influence. So Deng believed in lawyers, but he believed in lawyers as an instrument of economic development and also as an instrument of repression of people who challenged his regime and policies. Deng had no intention, just as Lenin had no intention, of having public lawyers emerge from legal education and the establishment of a legal profession again in China. So that continues to be, of course, a major problem. You could say that Deng wanted lawyers to be highly professional technicians very much like dentists. And the question has been in recent decades, can China benefit from? Can it welcome lawyers who go beyond that? Lawyers who want to be public lawyers, rights lawyers, criminal defense lawyers, public interest lawyers. Unfortunately, Xi Jinping has embraced the Deng model. He has not, although there's been some propaganda associated especially with the fourth plenary session of the recent party Congress that emphasized constitutional law and the legal system and fairness, there have been a number of very nice statements that sound very good. And there's been some improvement in legislation, also some setbacks in legislation. But in practice, Xi has really ruthlessly now suppressed efforts to have rights lawyers function, to allow criminal defense lawyers to operate according to the law in unrestricted fashion. Xi has begun to repress many NGOs that are trying to promote, even those trying to promote communist policies, and their lawyers. This is a very sad situation. And it's one that we're likely to confront, as I said earlier, for a number of years. Now, in these circumstances, what should be done? That's really the dilemma for some of you in the audience today who come from mainland China. This is not a new problem, as you well know. I remember in March 2006, sitting in the coffee shop of the Kerry Center Hotel in Beijing with a group, must have been 10 or 12 human rights lawyers, including Gao Zhisheng, the man who had already become famous and indeed recognized as one of China's best lawyers and who specialized in human rights questions and in litigating cases that challenged the government, even in economic circumstances. And by March 2006, it had become clear that the optimistic era for law reform that prevailed in the year 2003, 2004, perhaps even 2005, was coming to an end, and that lawyers and the legal system were going to be under increasing party and government pressure. And the question they discussed was what to do about it. Most took a practical view. They realized they were going to have to be fighting, challenging the government in court with one arm figuratively tied behind their back because of the restrictions in practice posed upon their efforts to use the legal system to defend human rights. But they took the practical view they really had no choice. If they weren't going to quit, they had to continue. And if they had to continue, they had to operate within the existing system or be punished and have their activities terminated. Most of them took that view. But Gao Zhisheng, a bold, dynamic, courageous person, he disagreed. He said, we can't limit ourselves to fighting within the existing restrictive system. As long as the party retains monopoly power in China, there will never be, he said, a genuine rule of law. So we have to fight for political change. Then they asked me, what did I think? And I said that, of course, I admired Mr. Gao, and I believed what he said was accurate in terms of prospects for achieving a genuine, you might say, Western-style rule of law, or a political legal system that meets universal standards today. But then I said, if he goes on talking like that, before very long, he won't be able to help anybody because he's going to be imprisoned. And I urged him to focus more within the possibilities of a limited, restricted legal system. Well, sadly, as you know what happened, he did get locked up very soon thereafter. And for the last decade, he's been in and out of prison. And this bold, courageous, dynamic, able person, through torture and long imprisonment, has been reduced to almost a vegetable. He is a broken person. And today, released from prison, he's really confined under a form of house arrest out in the countryside of his ancestral home, while his wife and children have had to flee to the United States because of the harassment and persecution that they themselves suffered. So this is a very sad story, and it's one that, of course, continues with respect to other human rights lawyers. We just had the unfortunate case of Puja Chang, and we have others that many of you are familiar with, and some of you undoubtedly have yourselves suffered sanctions because of your human rights activity. It's one thing to participate as a public lawyer in a society that is in transition from authoritarian dictatorship to democracy. But it's another thing to participate as a public lawyer in a society that's transiting to the wrong direction, that's moving from dictatorship to more severe dictatorship. And this, I fear, is the dilemma of Chinese public lawyers today. I wish it were otherwise. I wish Xi Jinping would pursue a different policy, one that his famous father advocated after he returned from 16 years of harassment and punishment in the Cultural Revolution era. When he was brought back to assume a major role in drafting legislation for the National People's Congress, 1981 to 83, Xi Zhongxun, the father of Xi Jinping, urged the enactment of a law that would protect people who wanted to express opinions that were different from the leadership, that disagreed with party policy. His lesson that he learned from bitter years during the Cultural Revolution was leaders are sometimes wrong. Leaders need the help of freely expressed ideas. China and the Communist Party can benefit from criticism and from alternative suggestions, and people should not be punished. And he said people should not be criminally punished for expressing differing opinions, differing from the leadership, and people should not suffer other administrative type sanctions. They should not be declared anti-party. They should not be fired from the Communist Party. And non-communists should also be free to criticize and propose other policies for the communist government. If Xi Jinping would honor those words of his father, I think the prospects for public lawyers in China would improve considerably, and indeed the prospects for China's future. Xi Jinping wants to keep lawyers as the equivalent of dentists, technical professionals who keep out of public affairs. I think that's the wrong way for China to go. And I'm happy to have an opportunity to present this view to those of you in the audience. Perhaps I'm preaching to the choir, as we say. But I look forward to learning the results of your exchange of ideas and your deliberations in Taipei this weekend. Thanks for listening.